So thank you very much for joining me here today. This is the first in a series of webinars that we at the commercial team at 5Paper will be hosting over the next couple of weeks. By way of brief introduction, my name is Tiernan Fitzgibbon. I'm one of the junior barristers here at 5Paper. And by way of background, before joining 5Paper, I trained and worked as a commercial litigation solicitor for 4 years, dealing in some of the clauses and situations that we're going to talk about here this afternoon. Just before we dive into the presentation, I've put everyone on mute automatically, as I think we're all fully aware at this point the problems that can cause if people aren't muted in these types of presentations. And I'm also going to leave space at the end if people do have questions arising out of the content of today's presentation. If people do have questions, I'll ask that they use the chat function and they can put them in there. But equally, I appreciate that the types of clauses and situations that we're going to talk about here this afternoon are quite specific and quite niche. So at the end of the presentation, I'll also have up my contact details. So if you prefer to contact me about any questions that you have afterwards, please do feel free to do so and get in touch. So with that, I'm going to share the slides that I've prepared today, and we're going to dive right in. So the first topic that we're going to deal with in this presentation is force majeure. Force majeure clauses quite often form a part of a contract's boilerplate provisions, but because they deal with exceptional events and circumstances, they're not that well understood by parties, purely because they're not enacted all that often. Even rarer still are situations where force majeure clauses go to the courts. And so you'll often find that there is a correlation between when force majeure clauses are in the courts with events of significant impact upon the world. And in English law, you'll quite often find them arising out of World War I, World War II, the Suez Crisis, the global financial crisis, or more recently, Brexit. So to help us understand force majeure clauses, we'll be looking at a sample clause, we'll be looking at their definition and scope, and we'll be looking at their potential impact if triggered. And in these times, what we have found is that companies are increasingly looking at enacting those force majeure clauses. So the article that I reference here is from late March about Primark cancelling hundreds of millions of pounds worth of contracts through force majeure clauses that it had contained with its suppliers' contracts. So when we're talking about force majeure clauses, the definition that I like to use is a fairly straightforward one. It's a contractual term that entitles parties to cancel, suspend, or vary their obligations under the contract upon the occurrence of events that are deemed to be beyond the party's control. And while the definition itself is quite straightforward, clauses involving force majeure can often be quite lengthy. And the example that I've put in the slides demonstrates that. It's taken from American drafting because it tends to be more encompassing, but it just goes to show just how detailed these types of clauses can be. So in this first slide of the sample clause, we'll see that the first thing that it sets out is what is the consequences of a force majeure clause, and that's excusing the parties from liability for failure or delay in performance. The triggering event for it is any event beyond a party's reasonable control. And the clause then goes on to provide a list of sample type events that may constitute force majeure. It goes on to provide a number of clarifications. Firstly, that the excuse from liability is only effective for the duration that the force majeure event is actually in play, and that all of the normal obligations will kick back into effect when the force majeure terminates. But it also requires that parties use good faith efforts to avoid the negative consequences of the force majeure event. So that sets out the scope and what it is that the force majeure event seeks to cover. The second element of the clause looks at the mechanics of how you actually trigger the force majeure event. So it sets out that notice must be given. It must be given no later than 5 days after the triggering event. And the notice must also set out the steps that the party has taken in order to minimize the impact of the obligations. The last element of the clause looks at what happens if the force majeure event goes beyond the time period envisaged by the parties and allows the parties then to terminate the event. So as you can see, effectively, a well-drafted force majeure clause should be a self-contained coda that seeks to envisage, in as far as humanly possible, what each step and element that it covers will be and the consequences of its impact upon the contractual obligations of the parties. So that's just an example of a type of clause that is frequently occurring in contracts. So going back to our definition, when we talk about a contractual term, the reason for that is that force majeure is not a term of art in English law. It's a concept that is borrowed from French, German, civil law jurisdictions. And so in English terms, it is very much a creature of contract. And therefore, when looking at force majeure as a concept in English law, what you have to go back to time and time again is the individual contractual clause that is at the heart of the dispute between the parties, because it's the clause itself that defines its scope. And that clause will be interpreted in accordance with the normal rules of contractual interpretation. So the clause itself will normally set out its scope by determining or providing for a list of events that it believes would constitute force majeure. But this is a very English-centered approach. And when you look at international contracts, you can quite often find a variation in those. Chinese contracts, for example, often delegate the responsibility of determining force majeure events to a central body of the Chinese government, who issue companies with what they term are force majeure certificates as evidence of force majeure having occurred or being triggered. In English terms, more contracts, more often than not, will specify the list of possible trigger events within them. But there is case law looking at where just the term force majeure has been used. But those tend to be quite older in origin. As you can see from the case that I've cited, it's from 1920. And so parties drafting has moved on much further since then to look at reducing and specifying the examples and situations where force majeure clauses can be triggered. So the second step of the definition looks at the consequences, and that is a cancellation, a suspension, or variation. And it very much depends on the contract itself. Thinking back to the sample clause that we looked at a couple of slides ago, that actually incorporated both a suspension of the party's obligations, but if that suspension went on for a period of 4 months, it also allowed for the cancellation of those obligations. So you're not just limited to one possible impact, and it's necessary to consider the whole gamut of possibilities that are contained within the clause itself. The last step of the definition concerns events beyond our control. So the trigger events will normally be set out within the clause itself, and they can range from as general as acts of God or acts of state to incredibly specific events such as influenza epidemics. And whether or not an event triggers or allows the triggering of a force majeure clause will be a question of fact to be determined by the courts. when interpreting the extent of the clause. Acts of God tend to be, and no pun intended, those acts of biblical proportions, once in a generation storms, incredibly rare hurricanes and typhoons. Merely unusual weather won't justify or won't satisfy a force majeure clause providing for an act of God. Acts of state are covered where there is, for example, expropriation of an asset on the part of the state. But one thing that emerged from the general financial crisis is that general economic conditions won't provide sufficient reasons, unless the contract is very expressly put on it, to trigger a force majeure clause. So the case that I cite on the slide is Tiernan Aviation Holdings. It's a 2010 decision, so arising out of the global financial crisis. And it concerned the purchase of an airplane. And the purchaser ran into difficulties effectively in getting finance due to the liquidity crisis that resulted from the global financial crisis. And it submitted a defense that was based on force majeure, citing that. And effectively, the court held that a change in economic or market circumstances affecting the profitability of a contract or the ease with which the parties' obligations can be performed will not, without express wording to that effect, constitute a force majeure event such that it could be used as a defense to allow a party to be relieved from performing its obligations. Quite often, the list of events that are incorporated within a force majeure clause will contain wipe-up wording effectively, something along to or any other causes beyond our control. Now, this is to make sure that such lists aren't exhaustive, but again, courts will construe such force majeure provisions narrowly in order to hold parties to their obligations. And so Tiernan Aviation Holdings is authority for the proposition that even if you include such expansive wording, the situation that is being invoked as the basis for the force majeure must be of a similar type to the events listed within the clause itself. And so even there, you are limited in terms of what you can possibly use to rely on. So the question then is, what impact does the force majeure event must have in order to allow a party to rely upon it? And effectively, there's three types of conditions that are normally contained in such clauses. The force majeure event must either prevent performance, must hinder performance, or must delay performance. Prevent performance is something that is akin to making the obligations physically or legally impossible to perform. As we've already discussed, merely making things more costly or reducing the profitability for parties in and of itself will not justify a party invoking a force majeure provision. The other important element in considering whether or not performance has been prevented is whether the alleged force majeure event is the sole reason for the party's failure to perform its contractual obligations. So the example that I look at is a case called Classic Maritime and Limbangan, and it's a quite recent decision last year from the Court of Appeal. And it concerned a contract for delivery of iron ore from a specific mine. The force majeure clause provided that one of the triggering events that the parties could rely on was a situation where the mine collapsed or an accident at the mine. And in this case, it did. But looking at the round and looking at the entire relationship and circumstances of the events in question, the court found that as the defendant had already missed 2 shipments prior to the mine collapsing, it would have defaulted under the contract anyways. The important point is that the Court of Appeal placed great emphasis on the fact that the force majeure clause required the event to directly impact the party seeking to rely upon it. And so as this party seeking to invoke the force majeure clause was already defaulting under the contract, it could not have been said to be directly impacted by the collapse of the mine, such that it could rely on the force majeure clause. Effectively, it's a but-for test. But for the force majeure event in question, would the party have been able to complete its contractual obligations in any event? Hindering or delaying performance are references to a lower standard. It has a wider scope than preventing, but it must relate to the actual performance of the contract itself. So again, a mere rise in the price of goods to be sold does not equate to a contract being hindered. Delayed then, again, is a lower burden and isn't the equivalent as being prevented. But normally these clauses are such that they just suspend parties' obligations rather than allow them to be terminated in their entirety. So conditional clauses. It's important to realize that with force majeure clauses, they're not absolute. They can have conditions placed upon them. The first of these, and one of the most common, is that it would require parties to attempt to mitigate the effects of the force majeure event before they could seek to rely on such a clause. They can also incorporate conditions precedent, and one of the more common elements of these are the mechanics behind which a force majeure clause is enacted in the first event. That will be by requiring notice to be provided. That notice quite often has to be provided within a certain period of time after the force majeure event has taken place, and it may require certain other proof which needs to be provided. It's a technical point, but if you're seeking to rely on a force majeure clause, you will need to make sure that you strictly adhere to all the technical measures that are contained within it in order to head off any sort of challenges when or if a dispute comes further down along the line. Quite often, as a good point, in such notices, it should be a good opportunity to demonstrate what measures you have taken to avoid the consequences, the damaging consequences of the force majeure event. So the burden of proof, as you would expect, is on the party seeking to invoke the clause. And as a base standard, they must prove that their non-performance was due to circumstances beyond their control arising from the force majeure event, and that there were no reasonable steps that they could have taken to avoid or mitigate the consequences of that event in question. So if you are looking to trigger a clause, these are the four considerations that you must really have in the back of your head. You look at, has a triggering event occurred? If not, you're taking a gamble then on possible wrongful termination and all of the consequences that flow for that. If there has been a triggering event, what are the consequences of it? What does the force majeure clause say in relation to suspension, cancellation, or variation? Thirdly, are there any mitigation steps which you can or should take to reduce the harmful consequences of the force majeure event? And lastly, when all the other elements have been satisfied, what are the mechanics for invoking the clause? What steps do you need to take in order to be able to rely upon it? In terms of what then are the effect of a force majeure provision, simply put, the effects are whatever the clause says that they are. And the rationale for this is that, as we discussed earlier, a force majeure provision is essentially its own coda that should specify all of the ramifications arising from a force majeure event. And typically, parties will bear their own costs in enacting the force majeure event itself. Quite often, these only will arise when it comes to termination clauses, where a contract has been suspended, everything is just put in abeyance until the force majeure event has ended, and then parties' contractual obligations come back to the fore. However, where payments have been described as non-refundable, unfortunately, they are treated as just that, unless they can be deemed unfair under consumer rights legislation. And that brings us on to fairness. And ultimately, where parties are treating and trading at commercial arm's length, it's unlikely that a force majeure provision would be deemed unfair, even where it only benefits one party. That changes when you're dealing with consumers, as consumers have the benefits of the Consumer Rights Act. And so where a force majeure clause hasn't been individually negotiated and fails to give consumers the same rights as the commercial party involved, it is quite possible that it could be found unfair under Part 2 of the Consumer Rights Act. So that's something to bear in mind depending on who the clause is dealing with. What then about our present circumstances? COVID-19 has already seen parties starting to invoke force majeure provisions, as we've seen from the article about Primark at the start of the presentation. And it very much does come down to what are the provisions contained within the contract itself. Unless the contract requires personal performance, it's highly unlikely that COVID-19 itself would provide the necessary trigger for a force majeure clause. It's much more likely that the acts of state as a result of a pandemic, the rules, regulations providing for a lockdown, preventing transport, preventing movement, would be used as grounds for triggering the force majeure clause. And so it's important, if you're going to trigger the clause, to really think through what is it actually that is preventing performance under the contract. And you must be specific rather than referring to a general catch-all such as COVID-19. Unfortunately, because these clauses are so incredibly fact sensitive, it's likely that parties will be in dispute about whether or not the provisions are satisfied. And so where you disagree that a force majeure clause has been validly invoked, parties should reserve their rights and consider whether it's in their best interest to accept the termination as a unilateral act on the other party and challenge it in the courts, or insist on performance and treat it as such. So looking at the second element of the presentation, which is about frustration. Frustration is a more general catch-all from force majeure because there's a number of important differences that apply. Whereas force majeure is a creature of contract that applies depending on the party's agreement and negotiation. Frustration is a doctrine of common law and applies irrespective of the party's individual contracts. Force majeure needs to be invoked by one of the parties before it can apply, whereas frustration applies automatically. Where they both are quite similar in their treatment by the courts is that they're both strictly applied and interpreted. So in order for frustration to apply, an event must be unexpected, beyond the party's control, and make performance either impossible or radically alter the party's obligations from what was envisaged on entering into the contract. Now, the basis of the doctrine historically was treated as being an implied term of a contract between the parties, but it's now more regarded as the courts imposing what the parties presumably would have agreed upon had they made express provision in their contracts. And so it just evolves the basis on which the court's looking at it. And so when you're considering the scope of the test, it must be an event that occurs without the fault of either party, and for which the contract makes no sufficient provision, which changes the nature of the outstanding contractual rights and or obligations from what the parties could reasonably have contemplated at the time of its execution. That both force majeure and frustration require without the fault of either party is a commonality between them, where a party brings about the circumstances that could result in either a force majeure clause applying or frustration taking place, it won't be allowed to rely upon that by the courts. And there have been cases where parties have sought and pleaded with their respective home governments to pass a piece of legislation affecting a contract that they've subsequently not been able to rely upon as justifying force majeure or frustration, precisely because they took active steps to bring that situation about. And so they could not then be allowed to rely upon it. So the application then of that test looks at what are the original obligations of the contract in question, bearing in mind the impact of the frustrating event. What is now required in order to give effect to those original obligations? And lastly, are these new requirements sufficiently radical or fundamental a change from the parties' obligations in order to render those obligations discharged? Frustration as a concept was frequently encountered by the courts in the 1950s in the aftermath of the Suez Canal crisis, because what ended up happening is that the major transit route was closed off to charter parties. And so the courts, in a series of decisions, held that notwithstanding that it was an unexpected event, they held that it didn't sufficiently or radically alter the obligations of the parties as they were originally envisaged. Because although the Suez Canal was closed, goods could still be transported via the Cape of Good Hope around Africa. And so it was a case of that it might take longer, it might be more expensive, but the original obligation of transporting goods could still be satisfied such that frustration as a doctrine didn't apply. And the reason that I give this is that it just goes to show the standard, the very high standard that the courts apply in determining whether there has been a sufficiently radical or fundamental a change. So much in the same way as force majeure provisions, a mere shift in the economics of a contract won't be enough to justify the triggering of a force majeure clause without express wording to that effect. The same applies with frustration, where the event means that it will be more expensive to perform, but it's still possible to do so. The contract won't be frustrated and parties will still be expected to perform. So it's an objective test. And the courts will look at the fact that although the parties may have foreseen the possibility of the frustrating event or new circumstances, that doesn't necessarily prevent the doctrine of frustration from applying. But it's a doctrine that is kept within narrow limits. And a good example of this in terms of foreseeability is a case called Flying Music Company and Theatre Entertainment, which concerned the hosting of a theatrical production in Greece during a time in which Athens is experiencing large amounts of civil unrest. That unrest was prevalent at the time that the contract was entered into. And when it became time for the performance to actually go ahead, that civil unrest was still continuing. Party argued that as a result, frustration applied and that the parties should be discharged of their obligations. But what the court held is that it was not beyond the realms of possibility that the civil unrest that was occurring at the time that the obligation and contracts were entered into continued, and that that was a risk that had been accounted for in the contract. What the court placed great emphasis on is that the level of civil unrest did not change from the point in time at which the contract was entered into to the point in time at which the obligations were expected to be discharged. Had there been a noticeable increase in violence or in the scope of the civil unrest, it is likely that in that situation, frustration would have been found to apply. But because in that particular context, there wasn't sufficiently radical change in the expectation of the parties' obligations, frustration wasn't held to apply. So again, it's a doctrine that is kept within very narrow limits, and courts are very reluctant to extend those. So if you are in a situation where frustration does apply, what are the consequences of such? The first thing is that you must look at severability of a contract. If the frustrating event only has an impact on one element of the contract that is capable of being severed, then the courts will do just that and sever the contract into its constituent elements. Where frustration does apply, the contract is ended and parties are released from further performance under the contract into the future. One of the key differences between frustration and force majeure is that frustration actually has some statutory underpinning, more importantly, in the consequences of frustration being found. And those are contained in the Law Reform Frustrated Contracts Act 1943. And as you can imagine, the reason that it's dated 1943 is due to one of the biggest frustrating events of the 20th century being World War II. And what effectively it does is it allows for sums already paid by a party to be returned, less any expenses already occurred. And that applies in respect of both goods and services. So the Act also allows for the court to identify a benefit that's been rendered, value it, and award a just sum in respect of it, take into account all of the individual circumstances and expenses that parties might have incurred. So it's seeking to sever the contract in a relatively equitable manner. Back in the days when Brexit was all we had to worry about, frustration cropped up in that scenario as well, and people were concerned with whether Brexit would intervene as a frustrating event. And one of the more recent cases, and one of the biggest cases looking at this at the moment, is Canary Wharf and the European Medical Agency, which was decided last year. And importantly, what the court held was that Brexit in and of itself, and the fact that the EMA had to relocate, was not a frustrating event. And again, the rationale for this was looking at the obligations of the parties as they were entered into, and the prevalence of break clauses and alienation provisions within the lease that the European Medical Agency had entered into meant that it was not beyond the contemplation of the parties at the time that the contract was entered into, that at some point during its 25-year lease, the EMA might have to move building, might have to move country. And so the mere incidence of Brexit being the driving force behind that relocation was not a frustrating event, as it didn't radically alter the obligations of the parties. But today, we're obviously dealing with our own particular set of circumstances in terms of COVID-19 and the current pandemic. And one of the best examples to look at how courts treat frustration in this type of scenario and situation is from the previous SARS epidemic. And so the case of Li Qingwing is a case from the Hong Kong courts, which was particularly affected by the SARS outbreak. And the case concerned a lease of a property which had been granted for 2 years, but during the course of the outbreak became subject to a closure order from the Department of Health, which meant it couldn't be inhabited by the tenant for a period of 10 days. It was argued that this closure order effectively frustrated the purpose of the lease, but looking at the obligations that the parties had entered into, the terms of the contract, and also the general economic purpose behind which it was entered, the court held that 10 days in the context of a 2-year lease was, again, not a sufficiently radical or fundamental change from what the parties had envisaged. So in the current context, depending on the type and length of the lease, depending on the obligations that the parties had entered into, whether the courts would allow for a 3-week period of closure or lockdown is at the borderline the longer that the current restrictions or provisions go on, the more arguable a case of frustration can be made. But in reviewing the authorities in preparation for this, I think that aside from a building burning down and not capable of being used for hire events, there hasn't been a frustration of a lease particularly in the last 100 years that has been upheld by the courts. And so again, it just goes to show that it is an incredibly strict test that is applied by the courts in determining whether a frustration event has occurred to allow the parties to walk away from their provisions. And so that brings us to the end of the presentation, bang on 35 minutes. So I'm just going to stop sharing the screen. And just make sure that there's been no questions. But as I said, the notes will be following out after this presentation, so you'll have a copy of them. And I appreciate that force majeure and frustration are quite specific in their application. And so a question may not be of particular relevance to everyone, depending on the specifics. So please do feel free to get in touch if you do have a specific question that I can help with. As I said at the start, this is the first in a series of webinars that We Have 5 paper will be doing. And the next one will be a recording released next Tuesday by one of our senior practitioners, Morwenna Macro, looking at applications in insolvency proceedings and what is required in order to prove your case. But otherwise, there's nothing further to say except thank you very much for joining us this afternoon. And I hope you all have a very good day and manage to enjoy some of the glorious sunshine that's outside. But take care.